I'd like to ask everybody if you'd please silence your cell phones and observe some decorum as if we were in a hearing here. You'll be given the chance to ask questions. We'd like to ask them to be questions and not speeches, please, and we'll be sure to get you an answer. I'm Shawn Meehan, the founder of Guard the Constitution, and today we are here because we believe the people have options to accept or decline debates, but when people call people liars, they have a duty to show up and make their case. Robert Brown and myself have been fighting against an Article 5 convention for years, and we were recently challenged with this slander by Mr. Meckler of Convention of States, and we invited him to show up and make his case and prove it. He has declined. So what we're going to do tonight is make this into an interactive class. We're humbled that the John Birch Society in at least 2, possibly 3 remote locations is also streaming this to legislatures in preparation of hearings they're going to have. So apparently somebody thinks that we know what we're talking about. We're going to do our best to convey that image. I personally believe that the Article 5 Convention is one of the most important issues. Wherever you're at on your personal preference, anything in the Constitution, Second Amendment, property rights, right to life, anything like that, they're all very important personal issues. But I think what we get caught up in our political passions is that if we lose the Constitution, the text and the understanding and the application of the Constitution by altering it, we lose the final firewall of liberty and our ability to defend all those other issues. So we encourage people to keep fighting their issues, but I think we need to prevent the Constitution from being rolled into the operating room for an unnecessary elective surgery. Tonight, Robert and Brown and myself are going to try to answer your questions and provide clear historical proof that the founders never said to amend the Constitution to enforce it, but we're also going to take a tack that there are solutions that even on our side of this fight are not often talked about. We're going to talk about them tonight. At this time, I'd like to introduce Boise State University political science professor Scott Yenner, who generally volunteered his time to be a moderator. And instead of needing a moderator tonight, he's going to help us by giving a brief introduction to what Article 5 is all about before we get started with our presentation tonight. Professor?
I was going to threaten to read the entirety of Article 5, but instead what I want to do is give a little account of why Article 5 arrived in the Constitution and discuss just a little bit about its nature. So Article 5 concerns the manner in which the Constitution will be amended, and the founders were looking for a way that would be partly federal and partly national in establishing this. So the mechanisms that they came up with were Congress and the states would, in different ways, be involved. Now, when you look at how they arrived at Article 5, and I have to do this because I'm blind from far, they initially said, we want to have a democratic way to amend the Constitution. Amending was part of the Virginia Plan early in the Constitutional Convention, May 29th. There wasn't a complete discussion of it, but George Mason, Elbridge Gerry, Edmund Randolph all spoke about the propriety of what they called the state-centered ratification process. And the convention itself approved a state-initiated call for constitutional convention as the only means to amend the Constitution on August 6th. The case seemed closed. However, more than a month later, on September 10th, just over a week before the convention broke up, 2 of the convention's major movers argued for the addition of another process, one whereby 2/3 of each House of Congress would propose specific amendments, which would then go to the states for ratification. It was a 1-2 punch that day. Hamilton insisted on the propriety of involving the national legislature in proposing amendments, as it would be, quote, the first to perceive and will be most sensible to the necessity of amendments. James Madison rose right after Hamilton and seconded his conclusion with an argument against the state-centered approach. Madison remarked, quote, "On the vagueness of the terms, call a convention for the purpose as sufficient reason for reconsidering what the Constitutional Convention had previously arrived at." He asked questions. How was a convention to be formed? By what rule would it decide? What force would be its acts? A few days later, Madison repeated the same criticisms. Difficulties, he said, might arise as to the form, the quorum, and etc., which in constitutional regulations ought to be as much as possible avoided. This would hardly be the last collaboration between Madison and Hamilton, but they got this amendment added, and it has been the only one used to amend the Constitution since. Madison, in the Federalist Papers, later reflected on what made the Constitutional Convention effective. This is just another thing. I think it's crucial for background as you think about the con. Madison talked about the conditions for having a successful Constitutional Convention. And he depicted the Philadelphia Convention as a kind of miracle. Madison reflected deeply on what had made the Constitutional Convention successful and what makes conventions in general successful. And he says that there are three conditions that stand out. First, the delegates and the country must be, quote, "deeply and unanimously impressed with the crisis." There needs to be a common understanding of the crisis, which prepares the way for a solution. However, such solutions never arise spontaneously and universally from the people. Instead, it is necessary, and this is the second condition, to have some patriotic and respectable citizen or number of citizens to make informal and unauthorized proposals for the people to consider for an up or down vote. These leaders are to be patriotic, as I say, the second, and respectable or seen as patriotic. That's the third condition. There was such a collection of patriotic citizens tested by fire whose disinterested love of country was plain for all to see. The citizens who do not spontaneously arrive at such a proposal could identify these patriotic citizens when they see them, and they would be inclined to defer to their genius. So I think these are the questions from the experience of the United States Constitution that have to be asked when one would consider a con. Is there sufficient popular understanding of what our problems of government are? Is there unanimity among the population about what those problems are? Are there great respectable leaders to lead a con? And would the people respect those leaders as respectable leaders? If the answer to any of these four questions would be no, then Madison would say no con. For a deeper historical understanding, I'm going to call on Shawn and Robert to present arguments. I'm going to sit over there, and I have to leave for a varsity basketball game in a little bit. But I thank everyone for coming, and Shawn's going to come on up and continue.
All right, what we're going to do now is I'm going to introduce the gentleman that was to be my debate partner tonight, but since the debate's not happening, he's going to be my co-presenter. We're going to try something new if it pleases the crowd. We're going to start off by asking you what you know of the convention already. If you're a supporter, we invite you to ask your questions, why you support it, what answers you may have either other way. Robert bills himself, and I think well-deserved, as a constitutional scholar. I don't know the material in my head to his level, but I do know it very well. He was one of my early mentors on this, and we're going to try to trade out a little bit and see what kind of a dynamic we can get going with the crowd to get you interested and make sure that you leave out of here not only being more aware of the details of the issue, but realizing how important it is and what you can do to act to prevent a convention from happening, but still fix the usurpation of our Constitution. So he's here with his lovely wife, Eve, tonight. They drove up from Utah. I'd like to introduce my friend and constitutional scholar, Robert Brown.
Well, thank you, Shawn. So I guess, are we both just going to hang out up here and take questions, discussion, that kind of thing? What I had in mind with the interactive discussion today, one of the best questions I've asked as I've met with legislators in particular is whether or not you support having an Article 5 convention, what do you feel are some of the most compelling arguments in favor of it? Because I think that's a good place to begin discussion. And so I want to turn to the audience. Does anyone have some thoughts on that topic? What do you feel are some of the more compelling reasons that maybe we should have an Article 5 convention? All the way to the back here. Good and loud so everyone can hear. Keep from doing a speech, but just a brief answer if you could. No speech. No speech. Okay, then never mind. I'm not going to call on you. Okay. So out of control spending, in addition to the emails requesting. So constituents, I guess you'd say on that as well. There's really 2 points there, constituent support, and I think we could probably all agree in here the federal government spending is not sustainable. Is that a fair assumption? So we agree on that problem, absolutely. Thank you. And so ways to address the out-of-control spending, some are billing the Article 5 convention as a way, or some cases, the only way. Good. Any others? And maybe we could chronicle these so that we don't forget them.
In process.
Got it? Okay. So that's really 2 different levels there. Any others that we want to put on the table here to begin some discussion of? Go ahead.
His reason for having the convention
Sure.
was campaign fund.
Want to repeal Citizens United, maybe?
Okay, yeah, and there are those who are promoting an Article 5 convention, generally from the left of the political spectrum. One group, for example, Wolfpack, which is definitely a leftist-oriented organization. They, down the chain, have some financial ties to George Soros, although they don't like to admit that. But one of the things they're pushing for is an overturn of Citizens United Supreme Court decision, which allows campaign funds, it allows corporations to donate campaign funds and things like that. And they're saying that's unduly influencing our elected officials, that kind of thing. So there's that side, and really there's some interesting dynamics between what those on the right of the political spectrum want and those on the left. But that's an interesting one. Is that one we should address? We might consider that one a little bit. Any others that we want to bring to the table to begin discussion tonight? Yeah, and that's fine, whether you're for or against a convention, just anything you've heard that sounds some of the more compelling ones. Go ahead. Yes. We had breakfast. You look nice, all dressed up, suit and tie. Okay, so feeling maybe powerless, Congress, the federal government doesn't want to fix the problem. Yeah. And so that'd be a good question. Is there, with the current structure, is there a way to get those problems fixed, or does it have to be done by changing the structure? Because frankly, the structure is defined by the Constitution. And so if there's a fundamental flaw in the way the structure was designed, that would be a case for we need to amend the Constitution, versus maybe we're just not using the structure properly. We'll get into that then. So definitely chronicle that one as well. I thought I saw a hand over here. Go ahead. Okay. And so term limits, there's a good one as well, in that will Congress propose term limits for themselves? And generally the argument's probably not, although there are some in Congress that support that idea. But as far as enough majority, 2/3 majority of the House, 2/3 majority of the Senate to do it, hasn't happened yet. There's also the argument of term limits on the Supreme Court. And frankly, with that one, I don't see Congress resisting it, and they're the ones that would need to do it. So I don't think that that one necessarily would be you'd need a convention to achieve it. So maybe we'll dismiss the whole Supreme Court one, although, interestingly, maybe not. We'll keep that one in mind, because that is one of the ones that Michael Ferris, one of the co-founders of Convention of States, that's his big push. He wants to see term limits on the Supreme Court. And frankly, we don't need a convention to get that one passed. But, okay, you got those chronicled? Keep it up here. Any others we want to bring to the table? Please.
So when I teach this, this is what I pose. The United States Constitution is dead. Based on it in Article 1, Section 8, have been violated in millions. Separation of powers doesn't work. All of the decision-making authority is in the executive. So itself doesn't operate on any level like it's supposed to. Federalism is broken. The government spends all of its time bribing the states to do what it would like it to do. So it couldn't be worse. We have an incoherent government, so whatever the Concom would come up with, if it came up with something, it and less coherence government than we already have.
Okay, so try to summarize this. Essentially, the system's already so broken that maybe the only way is to revisit. Yeah.
The call for a Concom is just out of desperation because the Constitution itself is dead.
Okay. So Constitution's dead, system's broken. Okay, and that is a perspective I've heard sometimes. Thank you. There's a hand over here.
So I'm gonna understand all this,
That's fine. There's probably others in the room that feel the same way.
I'm sure.
There's a great point, and that's another problem I think we probably can all agree on, that decisions for what's best in Idaho are coming from people who have no idea the needs of Idaho. That on a national level, these decisions are being made for us. Whether it be wolves, for example, not too long ago, the state of Idaho declared, we're going to take over the management of our wolves despite what the federal government says, because their program is not working here. The governor backed it and began that process. So yeah, there are times where federal government's clearly not doing what is in the interest of the local people, and that decision-making process should be here. And constitutionally, it was designed to be local in most cases.
Robert,
Excellent point.
Are you saying that the state of Idaho told the federal government to pound sand because they didn't have authority in an area?
They didn't use those words. I don't know if that can be picked
We
up on
wanna
the
explore
live
that
feed, but
concept a little
yeah,
bit.
and that's something we'll want to go into as well, is that the state of Idaho did tell the federal government to take a hike when it came to their regulations regarding wolves. And when you do speak, let's make sure we get you so that the people on the live feed can hear you as well. And for that reason, I'm repeating whatever is being said so we can make sure everyone in here and elsewhere viewing this can follow along. Was there another hand? That's a good place to start. What about reasons for not having an Article 5 convention? There's a hand right here. Okay. Okay. So to summarize, Article 5 is fairly vague on how the process is supposed to work in a lot of the details. About the only part you see that seems fairly spelled out is that Congress will decide which method of ratification would happen thereafter. But otherwise, it's kind of a vague, and who makes those decisions? That's something we might want to get into as well. I think we have a pretty good starting point, and I'm kind of at a decision point here whether I want to get into some of these questions first or address a few things as well. What do you think? Do you have something you want to go into here first?
I could tackle the out-of-control spending.
Okay. Come on over.
Everybody got their pocket constitutions handy? Article 1, Section 8, enumerated powers. Federal government's allowed to do this and nothing but this. Anybody ever run the math? If they only did that, somewhere between a 70 to 80% budget cut. How does that, hey, there's some clapping in the back, all right, somebody's paying attention. So here's how we do this, and this takes men and women of character, your legislators, and citizens of character supporting those legislators. They need to tell the federal government when unconstitutional federal spending is sent down, thanks but no thanks, we don't want to take it. Oh, the horror of that. People will be jailed, there'll be riots in the streets. That's just simply not the case. The founders intended for the federal government to serve the states, not the other way around. We created the creature doesn't control us. What you need to do is whatever your position is on marijuana, the federal government has no authority to regulate what plant you grow and put into your body. And you don't have to be for it or against it. It's the principle of the federal government not being empowered to do it. So certain states have told the federal government, thanks but no thanks, we're going to do what we want to do, much like the wolf thing. And it requires not just your legislators, because we have a habit in this country of loving to email and flog our legislators when they do something we don't want. And yeah, they listen, but I think they get sick and tired of it. But where are the people in any kind of numbers before these things happen, supporting them, telling them you're going to be there for them, telling them to push the lobbyists out the door and that you in numbers are going to be there to support them? This has been done. Several states with the Real ID Act resisted that for 15 years or something like that. It's creeping in, and that's fine, but the point was made is that it was done, it was resisted, states stood up. There's raw milk issues where certain communities, for certain belief sets that they have, they're being interfered with the FDA. Again, you have a right to put into your body what you want. The problem, I think, in practice ends up being that good-hearted Americans know that for about 100 years or more, we've been taking a progressive course away from our Constitution, and we want it. We all want it back now, and that's the right attitude. The problem is prosecuting that is not going to happen. We've been dissolved through incrementalism. We have to get it back, maybe through accelerated incrementalism. We have to get the wins where we can get the wins. And that's where the absolutists harass the legislators, nothing happens, we don't get anything done, and we wake up tomorrow and we are where we are or further slid down the hill. We have to adjust our approach. So as far as the out-of-control spending, there's many ways to address that. There's a lot of people in Congress that offer bills that mean nothing and it doesn't go anywhere. But we, the people, have to stand up and maybe not a broad cut, but let's pick one department or let's pick something in the federal government where we can get a number of state legislatures together to start pushing back. Maybe a 3% reduction in the money that comes to them that they take. They got to stand up, and whenever we've stood up against the federal government, I haven't seen in recent times where there's been violence. Everyone's, oh, there's going to be shooting, there's going to be the Bunkerville thing we had down in Nevada, the thing they just had in Virginia. Everyone was scare tacticking, oh my gosh, you don't have the authority, there's going to be not a shot fired. Patriots did the right thing and they stood up. It's not going to happen overnight, it's not going to happen tomorrow. But Article 1, now here's what happens with that real quick and I'll end that point. The people that are pushing a balanced budget amendment, and it's not specific, I don't believe, to the Convention of States petition, but it would fall underneath one of their three areas if they wanted it, is fiscal restraints, if you pass a balanced budget amendment, What you're doing is you're legitimizing the usurpation of the Constitution because you've taken what will be a recently ratified authority to a fiscal point. We're spending this amount of money and nothing more, and the enumerated powers that we've been ignoring for a period of time will continue to be ignored. So now, as long as we meet this dollar amount, we can spend money on whatever we want. And do you really think any level of the government without incredible activism is going to cut the budget? So if you don't cut the budget and the budget's balanced, what did you just do, ladies and gentlemen? You raised your taxes, fees, and assessments. That's the moral of that story. How about we do you want to address the Wolfpack one? Citizens United, that's kind of we don't get that one very often.
No, we don't. No, we don't.
The constituent support was another reason to have one.
Yeah, and that one's interesting.
Talk about republicanism or
Okay.
go for
There's
that
a
one.
hand back here as well.
Okay.
Let's go to your hand here.
appropriate, but, so if I'm understanding what you're saying, is that we just
Take a bite of the apple. You can't eat the whole apple
Yeah.
at one.
Oh,
the question really
I-
applies then,
Go ahead.
why,
You want me to take that?
I'll finish
I
up
will.
with
Go
that.
ahead.
I'll finish up with that. And let you take a second. I'll give our opponent, who's not here, Mark Meckler, I'll actually give him a kudo. Now, he didn't found the Tea Parties, but he takes credit for it. He, in a certain kind of a way that we're not going to discuss, kind of tried to unite them. But if you remember the Tea Party movement, they got some good legislators elected. They did some good work. Poof, they're gone. This is a long slog, every day, love your country, wave the flag, pray to your God, read the Constitution, fight. We can't stop. Some good work was done, and the good work stopped.
Yeah. The old phrase, the price of liberty is eternal vigilance, come to mind. The real issue, though, let me give you a little bit of my background of what got me to where I am today. Because a little over a dozen years ago, I had never read the Constitution, no idea what was in it, but had respect for it. That's about all I knew, really. Friend and neighbor invites me to a class on the Constitution, which he informed me was going to be held in my living room. And so I attended. But that story is pivotal in my life because when I went through that course, number one, it awakened a passion in me that I didn't know I had. A passion to understand the Constitution and the wisdom of the Founding Fathers in creating our great nation. And I realized two very important things. Everyone stay sitting down because I don't want to shock you too badly here. But we're really not using the Constitution anymore. Not seriously. As the professor mentioned in his comment, the Constitution is effectively dead. I wouldn't say it is completely dead because I think we'd all be shocked to see how much worse it can get if we truly had no Constitution starting tomorrow. But just the same, why? This is the second thing I realized. The main reason we're not following the Constitution is because we, the people, are supposed to be the natural guardians of the Constitution, according to Alexander Hamilton, Federalist 16. And how many of us know what it says? I've had the wonderful opportunity to travel the country teaching the Constitution. And one of the things I love to do is start off, now, who's going to show up to a class, public meeting to learn about the Constitution? Generally, people who already have some idea, some love for it, some degree of patriotism, and maybe even some background studying in the Constitution. This isn't going to be everyone in the community, is it? And so you know that you're going to start off in that group with people that are a little bit ahead of the game. And I give them a pop quiz on the Constitution. And pretty much everyone in the room fails. And realize, I guess I didn't know the Constitution as well as I thought I did. In fact, I had an opportunity on a radio show recently. The radio host felt like, yeah, I'm pretty good at the Constitution. I know it pretty well. Give it to me right here on the air. Okay, great. And to his credit, he got 7 out of 10. He did pretty well, quite a bit better than average. And yet, he felt very disappointed. He thought, he was going to do better than that. But that's really the problem. How can they in Washington, D.C. be expected to follow the rules if the referees, which is supposed to be us, have never read the rule book and aren't holding them to it? It's a very natural consequence, isn't it? And so I wouldn't say the Constitution is dead and not of any use to us anymore. It needs to be picked up, dusted off, and used again. And before we finish tonight, I'm going to give you some examples of ways in which I've done that were surprisingly effective. Go ahead. To restate for everyone to hear, as well as those remotely. So in beginning to understand and apply and use the Constitution, how would Article 5 not be part of that? How using Article 5, the people expressing their voice, their discontent with what's going on or whatever. For that, I would simply ask the question, what is Article 5 for? I ran across a picture the other day on the internet where there's a lady with a handgun flipped backward, and she's using the butt of the gun as a hammer to hammer in a nail on the wall. A few smiles, because that's not the way it's supposed to be used, right? That thing's loaded. If it's cocked and ready to go, it might be a dangerous attempt to try to use a handgun to hammer in a nail. So what is Article 5 for, and what is it not for? Please don't go try that. I don't want to suggest anything. What's that?
It works well.
It works well. What could possibly go wrong? Shot in your toe or something. Yeah. The purpose of Article 5. I am not against Article 5, just so you know. I accept the whole Constitution. There are some things in there that I love more than others, but it's the law of the land and it should be enforced until properly changed through the amendment process, including Article 5. But if you look through the Article 5 history, those promoting an Article 5 convention, just briefly here, see if I can get this to advance, there we go, claim that the Article 5 convention is for reining in an out-of-control government. Has anyone ever heard claims like that? That's what it's in there for, is to rein in the federal government when it oversteps its bounds. And they never said that. No founder ever suggested that if the federal government is ignoring the Constitution, we should use Article 5 to then change it. In fact, I'll jump ahead to what they actually said. Every time you see the founders talk about using Article 5, I found this was an interesting study. Every time you see them talk about using Article 5, it's in this context. It's for supplying for any defects that may be found in the Constitution. It's for the amendment errors that might be in the Constitution, and so on. They always talk about that as if there's a problem with the Constitution itself, then Article 5, whether it be amendments through Congress or through the convention, would be a proper approach. On the other hand, this comes from Federalist 49. In this one, James Madison, and by the way, does everyone know what the Federalist Papers are? Very simply, Federalist Papers were letters to the editor in the newspapers of the state of New York, written by three of the founding fathers, James Madison, Alexander Hamilton, and John Jay. And it was to help the people of New York understand the Constitution, how it is supposed to how it's supposed to work, how it's supposed to be understood, how it's supposed to be used. And in Federalist 49, James Madison asks the question and then answers it. Would an amending convention be an appropriate tool for correcting breaches of the Constitution? When they violate the Constitution, is this a good way to rein them in? I thought that was interesting because that's exactly what various organizations today are saying, isn't it? Now, Madison's argument is no, absolutely not. That's not what it's for. In fact, he, in a nutshell, says, if you're having trouble electing people to Congress that are going to follow the Constitution, you're going to get the same kind of people as delegates to the convention. As he says here, the convention, in short, would be composed chiefly of men who had been, or actually were expected to be members of the departments whose conduct was arraigned. Those who are out of control are likely to be the same type of people that are delegates to the convention. You're going to cause problems, letting them be the ones that are making the changes to the convention, at the convention. If you're having trouble selecting good people to follow the Constitution, you're going to have the same problem getting delegates to the convention. Interesting. But then he also ties in Federalist 48. At the end of 49, he says, and remember what I just said in Federalist 48. What did he say there? In Federalist 48, he says, parchment barriers, a piece of paper, is not an adequate barrier to tyranny. That if they're not following the Constitution, putting up new barriers of paper isn't going to help. In fact, his conclusion is, he says here, the conclusion I'm warranted in drawing from these observations, a mere demarcation on parchment of the constitutional limits of the several departments is not a sufficient guard against those encroachments. What he had spent several of the Federalist Papers before describing, including Federalist 46, is how to enforce the Constitution. And if we're not enforcing the Constitution, then the problem isn't we need to go change it. The problem is we need to start enforcing it again. If we were, as Shawn mentioned earlier, to dust off the Constitution and start demanding that they follow the enumerated powers, and the budget starts to be trimmed down to fit within the constitutional authorization, we'd be looking at somewhere in the neighborhood of $2 to $3 trillion of surplus in our annual budget. $2 to $3 trillion of surplus annually. Then there's a long road to hoe to get back to that, but it really comes down to where's the real problem? Where's the real problem? And I would say it's we the people. I see several hands here. You haven't had a chance to speak yet, and we'll come here and go back there again. Go ahead. Sure. Right. That's excellent. Okay, excellent. So there's really two things to address there. First of all, the balanced budget amendment concept. There is one proposal that has been around for decades, really since the 70s, that states have applied for a convention wanting a balanced budget amendment where Congress would be required to balance the budget in the absence of a national emergency, which is what you're describing there. And that emergency clause means that as long as there's no national emergency, Congress has to balance the budget. When was the last time that was the case? When was the last time that we were not under a nationally declared emergency state? Because if we had this balanced budget amendment passed years ago, can you point to any years? In fact, 1983 was the high watermark for it. In 1983, we were 2 states away from having that convention. Based on 32 out of 34 states needed had applied for a convention for this balanced budget amendment. So let's just say we'd pass it then in 82 to 83 range. Is there any year between there and now that they would have had to balance the budget? The answer is no. We've been under a constant state of national emergency since 1979. Last check, we were over 30 simultaneous states of emergency for various reasons, each one of which would disqualify this amendment from requiring Congress to balance the budget. So it wouldn't balance the budget, but it does open the Constitution. And anytime you open the Constitution, you got to realize when you get a law made and it's a bad law, it's pretty hard to get rid of, right? When you get a bad amendment to the Constitution, that's a higher level of difficulty. It's almost like etching in stone. The Constitution was intentionally more difficult to amend than are the laws of the state or of the country. And so if we make mistakes in the Constitution along the way, such as the 18th Amendment, fortunately, that one was a big enough mistake, the crime that it led to and so on, 10 years later, it was repealed with the 21st Amendment. Prohibition of alcohol, for those who don't have all the amendments memorized, sorry. So the 21st Amendment repealed prohibition. If we make a mistake in there, that's my biggest concern. If we get something codified in the Constitution, it would be very difficult to ever get it back out again. You also asked about a runaway convention. That's definitely something I want to get to, and we will. Because Let me just do that right now, because it's something I think is essential, and, yeah. Go ahead. Come back over.
Real quick point to the lady's question to close the loop. When I was researching this for a project in my state legislature, found I believe it was like a Sunshine Foundation was the name of the group. There was a study done during the mid and late 1990s. And we all remember that was the internet boom, and tax revenues were soaring because of capital gains and taxes and things like that. There were, I believe it was 49 of 50 states required a balanced budget. 2 were by law, the rest were by state constitution. And during the period of that study, there were no less than 26 states that were required to have a balanced budget, but did not, during a period of incredible revenue. I think if there's going to be a balanced budget amendment, it needs to say we want to balance the budget by following Article 1, Section 8, comma, and we're serious. That's the only amendment that could be supported.
I agree with that. And interestingly, none of the balanced budget amendment proposals say anything, that I've seen, say anything about getting back to the enumerated powers. They let that part slide, which does, in effect, codify the usurpation that's happened, as Shawn mentioned earlier. I want to get into just a little bit of the concept of a runaway convention. That's one of those never-ending battles on the two sides of this argument. Those who are in favor of a convention say that can't happen, generally. There's no way we could have a runaway convention. There are too many safeguards or whatever. And on my side of the argument, there's some serious problems here. Because, for example, in fact, let me just play a quick audio clip. Mark Meckler is the founder of Convention of States, and he was on your local public radio, Nate Shellman's show here 2 weeks ago. And in there, he addressed this question. Let's see. So he addressed the question. A caller called in and said, the 1787 convention was a runaway convention, and it's really the only precedent we have for a modern national constitution amending convention. The 1787 convention, by the way, that's where the U.S. Constitution was written. Here's what Mark Meckler had to say on that.
And because his underlying premise was 1787 convention was a runaway convention. It's, you know, the premise is the whole thing ran away. That's actually just a lie and a slander against the founders. Here's the deal. He hasn't read the commissions of the delegates who went to that convention. All of them, except for one, had this language in it. The commissioner has any and all authority necessary to render the federal constitution adequate for the exigencies of the union.
Okay.
Get ready, here's where it gets fun.
This is. And here's the problem. You hear what he just said? The previous caller obviously has not read the commissions that the delegates had in 1787 because that's a slander and a lie they had. And in his words, let me jump. I actually have a slide for this. Let's go back to here. This is an exact quote from what you just heard. All the delegate state commissions, except for one, he said, had this language in it. The commissioners has any and all authority necessary to render the federal constitution adequate for the exigencies of the union. So these guys had all authority. Here's the problem. I've read their commissions. In fact, I have them right here. The state resolutions calling for the 1787 Philadelphia Convention, and none of them say that. Not one. Now, there are several that are kind of close. They don't have this any and all authority section in there. That's an embellishment. Yes, several of them did say, we're authorizing our delegates to render the federal constitution adequate. But is that a grant of any and all authority? If, for example, they followed up with further restrictions, for example, several of the state delegate commissions said, yes, you have the authority to render the federal constitution adequate. What was the federal constitution at the time? The Articles of Confederation. And so you have the authority to render the Articles of Confederation, the federal constitution, adequate to our exigencies, meaning our urgent needs. But you cannot change, for example, we already have term limits on Congress. That needs to be preserved. We have a power to recall our members of Congress. And we have equal vote for every state in Congress. These are some of the restrictions on the authority of the delegates. Do they have any and all authority? If you're putting restrictions as well? No. Now, obviously, Mr. Meckler and I don't agree on how much authority they were given. So I think the best place to look to settle this argument is, what did they think? What did the delegates in 1787 believe was their authority? Because this came up. When the Virginia plan was presented, there was a question raised. I'm going to jump ahead here. There were those that raised the concern, wait a minute, you're proposing what is essentially a new constitution, not just amending the Articles of Confederation, and a new form of government. For example, you have Patrick Henry, that they exceeded their power is perfectly clear. And by the way, all these quotes are in the handout. Did everyone get a copy of this handout here, this two-page, it's actually two sides of one sheet. It looks like this. On the bottom of the second side, it says guardtheconstitution.com. Because here's the one thing, I don't want you to just trust me that I'm telling you these quotes or whatever. At the bottom of the page, you'll see that every one of these is cited where you can go look them up and see the context of where they came from. Because I want you to know for yourself what the history books say. Because they don't say what the convention promoters are claiming. Not at all. So here's the second one, Robert Whitehill. And this is in the Pennsylvania Ratification Convention. So after the Constitution was done, it was written, it goes out to the states for ratification, the debate came up again. Did the convention actually even have the authority to give us this new form of government, this new Constitution? And there were those like Robert Whitehill who said they didn't have the authority. Here's another one. William Patterson said we ought to return to our states and get more authority. We don't have the authority yet to do this massive change. They gave us limited power here. We're just supposed to amend the articles, not replace them. So there are several of those who had that kind of position. Two delegates here, Charles Pinckney and Elbridge Gerry, saying the same thing. John Lansing actually left the convention over this and didn't come back. Here's an interesting one as well. Luther Martin, that when the states realize how much we have abused their trust, they'll never trust another convention. And here we are, 200 and almost 40 years since, and we haven't trusted another national amending convention. So he's right on that. Now, with most political issues like this, there's usually two sides to the argument, right? So on the one hand, we have delegates in the convention and afterwards who said that convention did not have the authority to replace the articles with a new form of government. What was the other side of the argument? The other side was essentially this. Yeah, you're right, we probably don't have the authority to do this, but we need to do it anyway. For example, Edmund Randolph from Virginia. There are great seasons when persons with limited powers are justified in exceeding them. Is he saying they had limited powers? That's pretty clear, isn't it? So his opinion, he's defense here. He's on the other side of the argument here saying, you're right, we don't have unlimited authority, but we need to do this anyway. Alexander Hamilton, one of the leading advocates of the Constitution thereafter, writing the Federalist Papers, to rely on and propose any plan not adequate to these urgent needs, these exigencies, merely because it's not clearly within our powers, would be to sacrifice the means to the end. It's so important we need to do it anyway. James Madison, these are unauthorized propositions, but they're essential. And here's an interesting one. Again, in the state ratification conventions, when it came up, so the convention overstepped their bounds. They didn't have the authority to offer this new constitution. It should be rejected. His defense of that charge was, you're right, the federal convention did not act at all upon the powers given to them by the states. But then he goes on to justify it, but the people are free to accept or reject it anyway. Okay. Now here's my question. People like the audio clip I just played from Mark Meckler claim, read their commissions. They had full authority. Isn't that what he said? They had full authority to make any changes necessary. Why didn't any of them say that? And the challenge that I've issued to hundreds of convention promoters and leaders of convention promoting groups, find me even one of them that said that. Find me even one who said, it's clearly within our authority. Let's proceed. We've been authorized to do this. Let's do it. None of them said that. And that's been the answer I get every time, is let's change the topic, because there isn't. The 1787 convention, they understood that they had limited power and that they overstepped those bounds. And there's no way around that history. Now, here's the question. Generally, when I get people to this point, the answer I usually get is, well, you must just believe that the Constitution was illegally adopted And why are you trying to defend a constitution you think is illegal? No, I don't. In fact, if you go back to your page here, column 3, and then you have 3B as the little box down here at the bottom. What authority did they say they were using? Because as the last one I just shared with you from James Wilson, we didn't use the authority from the states. We didn't follow it at all. What authority did they say they were using? And I'll come to your question in just a second here. The people. In fact, the first quote in that box is the one right here, where during the convention, Madison described, here's how we resolve this debate between the two sides saying we don't have the authority and we shouldn't proceed. Yeah, you're right, we probably don't have the authority, but we need to proceed. This is how they resolved it. The people were, in fact, the fountain of all power. And by resorting to them, all difficulties were got over. They could alter constitutions as they pleased. And I would add, despite any limits they were given. Do you see the point here? What is the precedent that was set here? Okay. Yeah, so can the states limit the convention back in 1787? No, they couldn't. They tried to, but the states were unable to limit the convention to a certain scope. Is that what they're being told today? Our state legislators are being told that if we apply for a convention for a balanced budget amendment, it is limited to only talking about a balanced budget amendment. Is that what the historical precedent says? It isn't, is it? Could the convention today say, hey, by resorting to the people, we can alter constitutions as we please? That's the history, isn't it? In fact, interestingly, on the back side of the same handout, you'll see that the states, ever since 1787, have followed this same precedent, that as they have state conventions, the state legislatures have repeatedly tried to constrain their state conventions and have been shot down again and again, that the people, in fact, right there at the top you have corpus juris secundum, where the members of a constitutional convention are the direct representatives of the people. You jump down to the next highlighted part. So therefore, their power may not in any respect be limited or restrained by the legislature. The legislature has no say in this. Is that what our state legislators are being told today? It isn't, is it? They're being sold the idea that you'll totally control the convention. Don't worry, they can't change the Second Amendment at a convention that was called for a balanced budget amendment. Because what state legislature would pass this if they knew that everything's on the table? We're opening up the entire Constitution for revision. It wouldn't be passing like it is throughout the states if they understood the historical and legal precedent that we have here. So right here we had a question. Ma'am? Does she still have a question she wants to address, and then we'll come over to you again? Okay. I'm not sure I understood your question there. So it's that I think for what we just showed, there is historical basis that conventions can run away. Is that right? What's that? 1787. The document we just showed here where the states gave the delegates limits to their power, they felt, whatever the case, we need to ignore those limits and do what needs to be done. 1787 was a runaway convention. Do you have that paper there? There you go. So that... Okay, that's a great question to discuss afterwards, if you'd like. But the main concern here is, yes, the convention historically has not been able to be controlled. The only precedent we have is 1787. And in fact, in that column 3A, I found that was an interesting one as well. There's a quote here from a Judge Caleb Wallace. He was one of our first members of the U.S. Supreme Court after the Constitution was adopted. And he was a supporter of this new Constitution, except he was so concerned about the precedent that was created by a convention where they overstepped their bounds, they ignored what the states authorized them to do. He was so concerned about that, he was recommending we should redo the entire convention. Start over with the states giving the full authority from the beginning so that we don't set a dangerous precedent. So you see that in the bottom part of 3A in the column there. We'll go over it here. You've been waiting, and we'll come back to your question here. Go ahead.
Talking about what you're talking about, excuse me, with the too familiar with how exactly that follow the state's commission.
Okay.
We're sending some.
That's an excellent question. Was everyone able to hear that? I will restate it just for everyone's purpose here. So if a delegate at the 1787 convention did overstep their bounds, if that were to happen again today, couldn't the states recall that delegate? And what would prevent them from doing that? And there are really a few different answers to that. I want you to answer, because I know where you're going to go too. But the first answer is simply this. What happened in 1787 that prevented them from being recalled? First order of business in the 1787 convention was rules. What were the rules? They set their own rules, and the first rule was, this is a closed convention. No media is allowed in here, and no one's allowed to talk about what we're doing on our day-by-day proceedings until the end. In fact, Madison, his notes that were meticulous, his notes of what happened day by day in that convention were not allowed to be released to the public until his death. It was a secret convention. They swore everyone in the room to secrecy. No one knows what's happening because, don't worry, whatever happens in the end, it has to be ratified anyway, so you don't want to watch how hot dogs are made, right? It's better just to eat it and not ever look at how it's being made. Same thing goes with legislation or constitutions. And so that's really the first part of the answer, but there's also some interesting legal precedent, which Shawn has ready, he wants to talk about.
To elaborate a little bit on what Robert said, anybody that's been to any kind of political convention knows that the person that selects the delegates and or the person with the gavel runs the convention. It's a fundamental principle of parliamentary rules that, and this is something that the promoters of the convention are dishonest about. They say, we write the rules. Yes, you write the draft rules. And any of us that have worked at conventions know that that's how you get your team to win, is you write the draft rules, and you make sure somebody's distracted by the orange juice maker when the rules are passed at the convention and implemented. And there's dishonest people out there. It was what we would call in Robert's Rules an executive session convention. Also, there's been 41 times that Congress has worked to pass bills to regulate a convention. Our opponents say, oh, they have nothing to do but ministerial power. Absolutely untrue, just ask Congress. And if they're right and we're wrong, what happens if Congress passes rules for a convention that they call? Our Convention of States opponents have actually admitted that there will be years of federal litigation. So let me get this right. One of the big problems that we all agree on is the federal courts are out of control. So let's call a convention so that Congress, that we rightly have issues with, can pass rules that some of us believe they're empowered to, and some of us do not. And then, for the home run, we can pass it over to the courts that we all agree we have problems with. But that'll work out okay. The 1973 Federal Convention Act was actually passed by the Senate, not the entire Congress. And there were several stipulations in there, and one
Quick point on it, passed unanimously.
passed unanimously.
That was an interesting point.
There's an important point to that. Is in there is, because it's called under Article 5 of the Constitution, Article 5 convention is a federal function. State law does not apply. Yes, that's absolutely correct, and we can discuss that later, Matt. Idaho v. Freeman, and as a law student, sir, you should know this, is moot. The court clearly said it's moot. It's irrelevant. But the issue was the ratification window. The issue was the ratification window. in that case. Not what we're talking about is control of delegates. So we're out. Sure, absolutely. It's worthy of discussion, and that should take place. The 1973 National Convention Act clearly exempted all delegates to a national convention from any kind of state punishment should they exceed their authority. It was ruled moot because the issue that the court was trying to process had expired and resolved itself. I believe, as Matt was saying, there's what I guess you would call some interesting case law or analysis concepts that perhaps if this happened again and there was similar litigation, that it might take a same mental analysis route. And I think that's a fair discussion that can be had. But as far as the case itself and the opinion having any effect, it's moot, it's irrelevant. But I'll go on and read an excerpt from one of my favorite books on the topic, Constitutional Brinkmanship by Russell Kaplan. And I'm going to read this really quick. This is an example of a state constitution and how these things work.
Grab my slides because I have it
Sure.
on the slide too.
When Pennsylvania called a state convention to work on their state constitution. When the Pennsylvania Convention of 1873 proposed a new constitution, along with changes in the Bill of Rights that went beyond what was sanctioned in their enabling act, they exceeded their authority. Suit was filed to prevent submission of the Constitution for ratification. The Pennsylvania Supreme Court admitted that the Constitution had acted ultra vires, which is they exceeded their authority. But before the case was decided, the Constitution had been submitted to the voters, approved by a majority, and the court said, quote, "The change made by the people and their political institutions by the adoption of the proposed Constitution forbids an inquiry into the merits of the case. This is no longer judicial." So if you tell me, as Robert Kelly did, the attorney for Convention of States across the hall 2 years ago, that they're going to go to the courts and this will be reined in and controlled, there are such things in Article 5, broad areas of it are one of them, that are what's called non-justicial. The courts will not touch them. And that's an important point, because when they sell you that the courts are going to be an important safeguard, you need to know that and believe that, and that's simply not the case.
Thank you. So again, and I would just get your name, ma'am, because I'm calling on you several times.
Yeah, I'm sorry.
What was your name, by the way?
My name's Sarah.
Sarah, okay. You still had a question, I think, you want to come back to, is that correct?
Yes, so a little bit earlier, I kind of begs the question. Harm in attempting that. Other than the back in the olden days in 17, even though the media argument would be very
Yeah.
hard, I would think, for out cell phones. If you know,
Right.
listening to the impeachment.
It might be. It might be difficult to do so. Interesting thing, what would be the harm? What's the real danger of a runaway convention? Robbery? Bribery. I would call it horse trading. This is how it's often described in state legislatures, where if you vote for my bill that you don't like, I'll vote for yours that I don't like, and we'll get them both passed. Package deal. For example, in fact, let me see if I can find in my slides. I have way too many slides here. But, yeah. That's a good one to start with right there. If we were to have a runaway convention, what would that look like? For example, Robert Nadelson is a constitutional law professor who is a huge advocate of an Article 5 convention. He works for a lot of the different groups out there promoting it. And just recently, he went on the radio saying, for the Convention of States in particular, this is what a runaway convention would be. He says, if 34 states adopt their their convention application, it can't consider increases in power to the federal government. It can't propose changes to the Bill of Rights because it can't propose anything outside of their stated agenda. That's what he's saying. So if we do have a convention that proposes those types of things, by his statement, it has overstepped its bounds. So, for example, there's an amendment proposal circulating right now that includes this language. It refers to federal law issued by the Congress, President, or the administrative agencies. Those of you who know what the Constitution says now, is that an increase, decrease of federal power? What does that change?
Extreme increase.
Big increase. This is a direct change to Article 1, Section 1, Clause 1. The first thing after the preamble says, all legislative powers, all lawmaking powers, herein granted shall be vested in a Congress. So all power on the national level to create law is in Congress. How much is given to the president? What if we have an amendment that has this wording in it?
Tell them where it came from.
I will in a moment. Patience. All federal law created by Congress, federal law created by Congress, the president, or administrative agencies. That would be a problem, wouldn't it? Now, where this amendment comes from is a little shocking. Because back in September of 2016, the Convention of States organization held what they'd call a convention simulation, what we often call a mock convention, where delegates, mostly state legislators from all 50 states, came together in Williamsburg, Virginia, and met for a number of days, proposed amendments. They boiled it down to 6 amendment proposals. And from that convention, federal, legislative, and executive jurisdiction proposal number 2 has that language in it. It says this: the legislatures of the states shall have authority to abrogate, overturn, any provision of federal law issued by the Congress, President, or the administrative agencies. So they're trying to give the states more power, aren't they? We want to give the states the power to overturn federal law. But in the process of giving the states the power to overturn federal law, they're accidentally, I believe, giving the president the power to create that law. And who can act faster? The president or the states? If the states are overturning law, the president can make law every day, and it takes a majority. Right. The president can and does create law. Yeah. Sure. And this is one of those things where you've seen what legal teams can extrapolate out of the Constitution and stretch it to mean, such as the Second Amendment, shall not be infringed, now means shall not be infringed except in cases of, right? That's a blatant stretching of the Constitution. In this case, you don't have to stretch it very far to say, hey, it's talking about the president creating law, why isn't he? And then justify him doing so based on this amendment. Yeah.
One, we don't know exactly who, they weren't necessarily. This isn't.
Right. Well, no, and what I'm not saying is this is what's going to happen. But this is an example of the types of things that could happen. Now, bear in mind, of the delegates that attended, most of them were conservatives. They only had a few days to do it, and granted, they didn't have enough time to really hammer out the details. But what I don't see coming from Convention of States leaders is that was an error that we probably should have hammered out further if we had more time. Instead, what I see them saying is, no, there's no problem with this at all. And denying the problem I see right before my face here. This was passed, by the way, with a, jump down the bottom here, an 86% majority, and 95% plus were strong conservatives in the delegation there. It was a very imbalanced convention in that regard. It wasn't what a real convention will be like in that regard at all. There will be moderates and liberals, and they'll probably be the majority. The conservatives will probably be the minority there. I want to show one other possibility here, and this isn't mock convention. This is, now again, changes to the Bill of Rights. Nadelson said you can't touch the Bill of Rights in the Convention of States application. And they published numerous things like this article comes from Convention of States website. The Second Amendment is not up for debate. The Second Amendment's not on the agenda. Here's our list of agenda items. It's not one of them. Okay? And yet, when pressed, just a couple years ago on their Convention of States Action website, the Facebook page, one of their supporters asked, so why not include an update to the Second Amendment? To make it read the way we want to read now. Liberals are constantly wearing out the point it was when muskets were around. Why don't we update the Second Amendment to apply to today's arms? Convention of States, their official answer was this. It's called a clarification clause, and that's very much on the agenda. Of any number of study groups that are currently being conducted around the country, composed of Convention of States project advocates and their state legislators. So they say it's not on the agenda and it's outside the scope of our convention, but then they also say we're planning to do that. I thought that was rather surprising, that they're actually planning to. So here's the real question. Which way do we read their convention application? Because with all of this in here, either we are taking a broad interpretation, and that really could be on the agenda. If we broadly interpret their amendment, or excuse me, their application for the convention, and the Second Amendment really does fit within it, then it's such a broad convention application that really anything could be. And it's not a limited convention at all. On the other hand, if we take the narrow interpretation approach, Second Amendment is not within the scope, then their convention is already beginning to run away. They're already making plans to exceed their own scope. Either way, I'm not sure I like the outcome there. Now, the real answer, though, the final answer to your question is this. What would it look like? Remember we talked about horse trading? You adopt mine, I adopt yours, that kind of thing. Not sure where I have this in here. I'm going to have to skip the slides on this one. But, oh, there it is. I found it. Number 49. So this is the Nation magazine. Does anyone know which way the Nation magazine leans politically? A little left, a lot left. So much left, I'm going to fall off the platform here. They're hard left, very hard left. And this article that they published, the U.S. Constitution is over 2 centuries old. It's showing its age. It's time to revisit it and rewrite the entire thing. That's their point. It's outdated. We need a new Constitution. They recommend the best way to achieve that is through an Article 5 convention. And they specifically say, hey, look, there are a number of conservative groups out there pushing for one. Let's help them get there. Specifically mentions the Balanced Budget Amendment movement and the Convention of States project. And then it says, rather than ridicule the efforts to adapt the Constitution for for present day, small d Democrats ought, with eyes wide open, to join them. And then what do they hope to achieve? So liberals, you need to go out there and help your conservative friends get the convention they're applying for, because here's what we want to achieve once we get there. Lawrence Lessig, liberal, former Obama campaign advisor and so on, says, the key is a simple compromise. We get to consider our proposals if you get to consider yours. So in exchange for the Balanced Budget Amendment, which we've already discussed isn't going to balance the budget, in exchange for you guys getting your Balanced Budget Amendment on the table, we want a repeal of the Electoral College, giving Idaho really no effective voice in the presidential elections. That's the trade. Balanced Budget Amendment that won't balance the budget, and you lose the Electoral College. All in favor? That's what a runaway convention looks like. Horse trading, compromise, and honestly, I have not seen an amendment proposal seriously put forward by the conservative side that I think would do any good. Now, there are some I would support, but I haven't seen any of them gaining any national traction to the point where they have any chance of really being on the table at the convention. Does that answer your question? What a runaway convention would look like, that kind of thing? That's what I seriously see. I don't see it being a complete repeal of the Constitution as much as serious horse trading, and have you ever noticed, from my perspective, anytime the liberals and conservatives come together and compromise, the conservatives do all the compromising? Yeah, so you had a hand here, and then we'll come over here. You still have your thought? Okay, great. Go ahead.
The Convention of States also has a booklet that they put out and all kinds of things on their own website. I think that just tells you the story that they want a wide open.
Yeah. You know, interestingly, and I don't have it queued up right now.
On the Convention of States website.
Okay,
I don't think that's the issue.
definitely, okay.
Ideas, some of them aren't good, but the issue is not whether they're bad or not, but whether we have a wide open convention.
And this is the point. This is the point. Yeah. So the question is, should we do the convention, or is there some other route that we can get back on track? Because that's really the real key. If that's our choice, do nothing and continue down a path that we know is going to lead to the demise of our nation. I'm sorry, we're running out of time, so I'm not going to be able to take more questions at this point, but I will stick around and do more discussion afterwards. But the thing I want to address as we wrap up here, is there another option? The founders very clearly said there's another option. Do you want to start with this part and me wrap up, or vice versa?
Once you hit Power 500,
Okay.
I'll talk about what we did in Nevada with national popular vote,
Okay.
and we'll head to conclusion.
Just as a quick overview, I refer to the Federalist Papers quite a bit. Madison clearly said that an amendments convention for correcting breaches in the Constitution is a bad idea. What did he say is a good idea for correcting breaches of the Constitution? I would point to Hamilton's Federalist 16, Madison's Federalist 46. Because in both of those, they talk about the power that we, the people, and we, the states, have to rein in the federal government to enforce the Constitution. And what I want to focus on specifically is something that we, the people, can do. And the reason I say this is I've done it. A number of years ago, I moved to Montana and I launched a program there where our congressman in Montana was a man by the name of Denny Rehberg. I'm going to just jump to that slide so we're there. This is what we call the power of 500. We're just a few people in a congressional district. Now, in Idaho, you have 2 congressional districts, right? 2 U.S. congressman seats. And so 2 teams of this power of 500 could address your 2 congressmen. Montana only has 1. They're the largest population congressional district. When I moved to Montana, this was our congressman, Denny Rehberg. His Freedom Index score, the Freedom Index is a scorecard based on the U.S. Constitution. How well are our members of Congress, House and Senate, following the Constitution? As you can see, his score history up there wasn't exactly stellar, anywhere as low as 30% to at one point, he got up as high as 67%, generally kind of that middle of the road, slightly below mid-zone, slightly below 50% is kind of his average. His last score when I moved there was 60%. I began organizing a team around the state of Montana, handing out his voting record everywhere they go. Whenever he'd show up to a meeting, I'd make sure that our people were there with his voting record, not just to talk to him about, but to hand to everyone else in the room. I remember the first time I did that, I was dressed about like this, stood at the door as people were coming into one of his town hall meetings. I just handed out his voting records as they came in. And pretty soon I heard people saying things like, I don't think that man was with Rehberg's campaign because this doesn't reflect well on our congressman. And then I just watched as the questions start shooting up in the audience. Congressman, I wanted to ask you about where you felt you had the constitutional authority for this vote. I didn't have to do anything. I just handed things out and they took it from there. And he sweated quite a bit in that meeting, but guess what happened 6 months later when his next score came out? His next score was 80%. The next one was 80%. We kept putting the pressure on him. He got up to 90%. At that point, I said, 10% more, I'll be out campaigning for you. You're almost there. Congratulations for your new high score. We had a very friendly relationship in this, and he even referred to Mr. Brown as my conscience and thanked us for keeping him on track. In a matter of just 6 months, we saw a marked change in his voting record. And then, unfortunately, he ran for U.S. Senate, and due to some mudslinging, he lost the election. So we had to start over with a new congressman that then got it selected for a U.S. federal position, and then so we had another one to start over. So each time we're starting over with a new congressman. But the point is this: we have the power. How many people does it take to rein in your congressman? You know how many we had at this point when I started seeing this massive change in him? Less than 200. Yeah, we call it the Power of 500 because with 500 you really have a solid team. But just a few hundred people holding him accountable, handing out his scorecard compared to the Constitution. Would this work with Nancy Pelosi? It wouldn't, I'll admit that. When you have someone that's hard left, they know you who are telling me you need to follow the Constitution aren't my real constituents. You're not the one that got me elected. They'll just ignore you. I have a U.S. Senator like that, John Tester in Montana. I tell him, you realize that vote you have no constitutional authority for. And his answer was, yes, but we crossed that bridge long ago and we're not going back. He doesn't care. So you want to start with those that are middle to right-leaning, those that are conservative or at least should be. But what if we did that across this nation? What if we got them, now, despite any Supreme Court decision saying, yes, this is constitutional, guess which way he was voting? He was ignoring the Supreme Court decisions because that's what his constituents want him to do. He was paying attention to what the Constitution actually says. Article 1, Section 8, enumerated powers, that's the direction he began voting, regardless of any justification courts might give him to the contrary. So that's just one quick example that, again, quoting Hamilton, we the people are the natural guardians of the Constitution. It's time we recognize that. It's time we step up to the plate and start holding them accountable, and it doesn't take a majority to make it happen. I want to have Shawn just give a quick example as well, because it really does come down to we the people. The states have the power to push back. We started with that with wolves and raw milk and things like that, but ultimately it comes down to we the people. Go ahead, Shawn, and I'll let you wrap up as well.
I also want to dovetail on what an angle on what Robert said. Convention of States currently claims between 3 and 4 million supporters. If you do the math versus the power of 500, they currently have somewhere between 20 to 40 times the people needed tomorrow in every congressional district to enforce the Constitution. We've shown you how they're not telling the whole story, they're not telling the truth in a lot of areas. We've shown you a solution they claim we don't have. We've shown you they have 20 to 40 times the people needed to implement that. It's very clear to me and other people in this fight that they don't want to enforce it, they want to change it. I'd like to give a quick example. I want to acknowledge Janine Hansen, a friend of mine. She came in here. She's the National Constitutional Issues Director for Eagle Forum. She fought in the trenches on this for years with Phyllis Schlafly. She was also one of my mentors in Nevada on this issue. And her and I together a couple sessions ago got a Democrat to sponsor Senate Joint Resolution 10. We passed it with 2 subcommittee votes, 2 floor votes unanimously, and we ripped out 10 Article 5 petitions pending from Nevada, one all the way back to 1901. So it can be done. But something else we did last session is even more cool, is we fought the national popular vote for a long time. Session before last, we killed it in the first committee. This time they got it all the way to the desk of our brand new Democrat governor. National popular vote's a core Democrat issue. I'll tell you, I went home frustrated, disgusted, put on my warm-ups, went and worked out, came back all hot and sweaty, and I turned on Facebook video. And I held up a phone number. It was the governor's phone number, Assembly Bill 186, wrote that below there, put that on Facebook. 5 days, 27,000 views, no money spent to advertise it. I called the governor's office. Oh, you're Shawn Meehan, we hate you. She's joking, of course. They wouldn't give me the specific numbers, but they would tell me we have gotten thousands of phone calls from across the country. A couple days later, I got a phone call at 6 a.m. from a friend that works for a state senator, says, check your email. It was a PDF copy of the governor's veto letter, his first veto. A leftist Democrat governor vetoed the national popular vote, a core issue. God was on our side, and it hit the press a couple hours later because he felt the pressure of the people. This is what the founders told us to do. If we care, we must be engaged. I'll close this by saying we're going to stay after for as long as we can. We're supposed to start moving out of the building at 7, but we'll answer as many of your questions when we're done as we can. I'd like you to make sure that you don't believe anything we say here tonight. Ben Franklin once said it is the first responsibility of every citizen to question authority. You need to go do your homework. Don't believe Robert, don't believe me, don't believe Mark Meckler. Do your homework. Don't read our handouts, don't read their handouts. Use them as source documents to go to the facts. You as a citizen live in one of the most blessed countries on the face of the earth. I've been to 54 of them in the Air Force. We have our problems, we have our warts, but we live in an amazing country. And we can save it if we're engaged. And I say this often because it's very important to me. Nearly 1.4 million troops have died in the history of our country to found her and to guard her Constitution since that time. I think we owe them a small bit of moral duty to enjoy it, live free, drink your beer, party with your friends at the lake, get with your ski boat, save, invest, build a house, do what you want to do with your loved ones. Worship your God the way you want to worship him. But at the end of the day, we have an opportunity and a duty, I believe, to preserve and lead this country and leave the woodpile a little higher than we found it. We need to become informed and not enamored by the shiny little people that come in and try to tell us stories. We need to honor those family, friends, and loved ones that are important to us. And I believe that doing anything less simply makes us not human, and it makes us unworthy of the gift of liberty. I look forward to you remaining engaged with guardtheconstitution.com because this is just a preview of what's coming. We've come up with a system we're fixing to roll out. I was stationed in South Carolina for 3 years, excuse the fixin'. But we're going to roll out some very interesting solutions, and Mark Meckler's never going to see them coming. And we're going to spread this message around and organize and activate, and we're going to guard the Constitution. I'd like to thank the legislators that showed up and helped us put this event together. I'd like to thank the affiliated groups that are leaning forward with new attitudes and working together. This has been live broadcast in 2, possibly 3 other state legislatures across the country. And I'll tell you, the founders gave you the task of verifying the facts and engaging with your state legislators. They are a firewall, but you're their firewall. You have to be there for them. In the 2012 Republican Convention in Tampa, Florida, Clint Eastwood said that elected officials are our employees. Sometimes we have to supervise them, sometimes we have to get rid of them. But they're our employees. Don't let them get the relationship backwards. Always remember that a free people follow the Constitution and do not ask permission to exercise their rights. Do not be violent, do not be angry, do not be charmed, do not be misled. Rather, be educated, informed, loving, passionate, committed, and actively pursue liberty, and help us together keep guarding the Constitution. Thank you for your time and attention. We're happy to chat one-on-one or in groups, whatever y'all want to do, or we can all go get pizza, whatever works.
Union Pacific Foundation, Boise State University's School of Public Service, Idaho Cable Broadband Association, Associated Taxpayers of Idaho, Association of Idaho Cities, University of Idaho's Meckler Center for Public Policy Research, with additional support from the Idaho Public Television Endowment.